everyone, good afternoon, and welcome back to Thorough Newspaper Analysis. Today is 3rd of June, and this entire video series is brought to you by LawSikho. Now let's head to the agenda for today. So for our editorial segment, we've taken up an Indian Express article which is titled as Unseeing the Crime. Here essentially we talk about the checkered history that our nation has when it comes to treating the survivors of rape and of sexual assault. We have a look at some of the very unfortunate cases that our nation saw, which shook us all, and we have a look at what were the developments in law post those cases of sexual crime. The second segment for our discussion is the news update segment, and thirdly, we talk about important legal developments of the day. So with this, let's start with the TNA, and first point of discussion would be this article, the title of which is Unseeing the Crime. This is going to be our order of understanding of it. First, we talk about some of the instances which throw light on this very proposition that we do in fact have a checkered history. Then we talk about how the survivors who should have been treated with utmost dignity and protection, they were disbelieved. Then we have a look at the law that shaped both these cases. See, India has a very checkered history when it comes to treating the survivors of sexual offenses, of sexual violence. To cite some of the instances, we have the 1972 case of Mathura rape, then we have the Bhamri Devi case of 1992, the Tarun Tejpal case of 2013, then we have the allegations that were leveled against the then Chief Justice of India, Ranjan Gogoi, in 2019 of sexual harassment by a staffer. And then we have the current wrestlers protest, which has been going on for 2-3 months now. And the wrestlers who have made us proud at the world stage when it comes to the sports category, they're now on the streets protesting against the powerful men in the establishment. Now let's understand, before we dive into the segment, I would like to take a few seconds to explain this case because it is very instrumental when it comes to the rape law that we have at this point in time. See, Mathura, she was a tribal woman of 14 to 15 years of age, and she was in a relationship with an upper caste boy. Her brother was against this relationship, and as a result, he lodged an FIR in the police station. In the police station, all the concerned parties, including Mathura, the boy, his family, the brother, all of them were called, and the others were made to wait outside the police station while Mathura was retained there in the complex in the room, and there she was raped by two policemen. What happened post this rape is indeed a sad state of affairs. So, when the matter reached the Sessions Court acquitted those two policemen on the ground that Mathura she was habituated to sexual intercourse and that her consent was voluntary. Then the matter reached the Honorable High Court of Bombay, where the High Court found them guilty on the premise that passive submission it is not equivalent to consent. There is a distinction between these two. And then the matter reached the Honorable Supreme Court, where the Supreme Court's judgment was severely criticized because the Supreme Court said that she was habituated to sexual intercourse. There were no injury marks on her body, there were no signs of resistance, she did not raise any alarm. So, this would mean that her consent was voluntary. And then in the case of Bhamri Devi, this is how the victims, the survivors, I'm sorry, they were disbelieved. So the trial court disbelieved that upper caste men would ever defile themselves by raping a lower caste woman. This is what the response of the court was post this case. And then we have the case of Tarun Tejpal here. The survivor was disbelieved for not behaving the way a sexual assault survivor would ordinarily behave. And the wrestlers protest case, you all are seeing what's unfolding at this point in time in our country. So this indeed reflect on the very sad state of affairs that we have in our nation when it comes to treating the survivors who should have been treated with utmost dignity and protection. And now let's understand as to what the law has been post these developments. So as far as Mathura's case is concerned, post this, the Supreme Court judgment, it was severely criticized and it prompted a lot of amendments which are indeed significant. We see a lot of amendments in 1893 in the IPC, especially the sections governing the rape law. We also see a crucial amendment in the Indian Evidence Act as well. So the Indian Evidence Act, it was amended to provide that in certain cases of rape where sexual intercourse it is proved, and the question comes to whether the consent of the woman was voluntary or not. So here there is a presumption. The court will have to presume that there was no consent. So presumption is of absence of consent, and if the accused wants the court to believe otherwise, then the burden to prove this otherwise factum, this is on the accused itself. And then we come to a year later where our country ratified two declarations which are indeed important ones. So in 1985, India ratified the Declaration of the Basic Principles of Justice for Victims of Crime and Abuse of Power. This declaration, it provides a framework for protecting and for promoting the rights of the victim to access justice, fair treatment, restitution, compensation, and assistance. India also ratified another declaration, which is the Declaration on Elimination of Violence Against Women. This is in 1993 declaration. It recognized the need for legal and support services for survivors and for raising awareness and changing attitude that perpetuate violence against women. The Supreme Court, it also recognized the importance of victims' rights and how it is important to rehabilitate them and provide them with protection and victim assistance programs and support services in the landmark case of Zaira Habibullah Sheikh versus the state of Gujarat. It has also held in several cases the apex court that the conviction of an accused of sexual assault, it can be sustained on the sole testimony of the prosecutrix, and there is no mandate in law that the has to insist on corroboration of the testimony of the victim or the prosecutrix, provided the testimony of the prosecutrix it is blot free and it is worthy of credit. Then we have the 2012 POCSO Act. This act, it also addresses sexual offenses against children, and it takes a child-centric approach when it comes to investigation, trial, and rehabilitation measures. Then, as far as the case of Bhavri Devi is concerned, I'm sure you all would know that this is the case which laid the foundation of the POSH Act. Post this case, in the landmark judgment of Vishaka versus State of Rajasthan, the apex court laid down guidelines to respond to cases of sexual harassment in the workplace. And eventually, the parliament enacted a law which is ordinarily called the POSH law in 2013. Now let's understand as to whether the objectives of these measures they are achieved. So if we have a look at data, the data would highlight otherwise. For instance, according to the National Family Health Survey 5, which was conducted in from 2019 to 2021, about one third of women they have experienced physical or sexual abuse, but merely 14% can either speak or they either spoke about it or reported it. So the rate of reporting these crimes it is merely 14%. And the reasons for the silence of survivor it could often be social stigma and the shame, the fear of retaliation, lack of trust in the justice system, the limited awareness that survivors often have of the legal machinery, and also there is a lack of support from the family and the community as well. If we have a look at the wrestler protest, it has helped shed light on the lapses in the implementation of the POSH Act. We've also covered this in our TNA as well, that the committee report, it highlighted that very few federations, the percentage is almost to nil. They have the internal complaints committee, which is mandated by the POSH Act for the purpose of addressing grievances of sexual harassment and of abuse. So this is what the author says at the parting note, and this is important that we, the people of India, should take a break from our tainted history. We should believe the survivors. We should demand the arrest of the accused and let the truth and justice reveal themselves. So with this, we proceed to the next segment. Also, before we do that, I have a question. So we discuss an Indian evidence provision, which is a result of an amendment of 1983, and post this amendment, I would like to ask as to which section is this which provides for the presumption of absence of consent. Kindly put down your answers in the comment section, and let's proceed to the next segment for today. And now we proceed to the national news category for today. First update coming from the state of Maharashtra. On the occasion of 298th birth anniversary of Maratha Queen Ahilyabai Holkar, the Chief Minister of the state he has announced that his government would rename the western Maharashtrian city of Ahmednagar after her. and Ahmednagar from now on would be called Ahilyanagar. Ahilyabai, she was born to the family of village headmen in Ahmednagar, and her father, contrary to the notion that was prevailing at that point in time, he made sure that his daughter was educated. Post her marriage, her husband he died in the Battle of Kumbher against the king of Bharatpur in 1754. Ahilyabai, she took control of Malwa and she excelled at administrative and military strategies under the guidance of her father-in-law, who insisted upon her abilities being used in the administrative field instead of subjecting her to the practice of sati. The third edition of India-Vietnam Maritime Security Dialogue, it was held and concluded in New Delhi. Senior officials from both sides and services concerned with maritime affairs, they participated in the dialogue. The two sides discussed ways to sustain a secure maritime environment which is conducive for inclusive growth. They also reviewed maritime cooperation initiatives and avenues of reinforcing international as well as regional mechanisms for comprehensive maritime security. AIIMS Nagpur has become the first among all the AIIMS to receive the prestigious National Accreditation Board for Hospitals and Healthcare Providers, which is at par with the world's leading hospital accreditation standards. AIIMS Nagpur, it is one of the four AIIMS that were announced during the budget speech of 2014-2015. This was under the Pradhan Mantri Swasthya Suraksha Yojana. It played a very crucial role during the dire times of COVID-19 when it stepped up to the needs of the society by setting up sample collection and testing facilities. Meesho has become world's fastest shopping app. The Bangalore-based e-commerce firm Meesho, it has emerged as the world's fastest shopping app to cross 500 million cumulative downloads. This is a milestone that has been reached in 6 years. Tata Consultancy Services, Reliance Jio, they are among the top best Indian brands of 2023. Technology giant TCS and India's most valuable company, Reliance Industries, they've topped the list of the country's most valuable brands. TCS, it has a brand value of Indian rupee 1.09 lakh crore, while Reliance bagged the second spot, and the third spot it has been bagged by telecom unit Jio. And this has brought us to the international segment for today. Elon Musk, he has reclaimed his title of world's richest person. Elon Musk, he has once again become the world's richest person, overtaking French billionaire Bernard Arnault. The third position, it is being secured by Amazon's founder and executive chair, Jeff Bezos. And with this, we come to the last segment for today. Here we have an update from the High Court of Delhi. The Honorable High Court of Delhi has recently held that the power of Competition Commission of India, it is limited to regulating markets and it does not extend to reviewing the decisions which have been taken by statutory regulators in exercise of their statutory powers. The court further observed that the scope of examination, it must be confined to areas of economic activities which have a bearing on the market that engages entities involved in trade and commerce. The name of this particular case is Institute of Chartered Accountants of India versus the Competition Commission of India and others. This has brought us to an end for the TNA. In case you want to get access to the free study material that we provide and the slides that have been used in this video, I would highly encourage all of you to please join our Telegram channel. And for the same purpose, you may scan the barcode here or you may click on the link which is provided in the description. These are the point of contacts in case you want to get in touch with LawSikho. Please put down your answers in the comment section for the question that was posed in the editorial segment for today. Thank you for being with us.